first barrister in Malaysia to be appointed directly to the appellate bench, he is no stranger to this audience, and his judgments are extensively cited throughout all levels of court in the country. When we asked if he would deliver a lecture at this event to give depth to our celebration, he graciously agreed. Datuk, you personally inspire me in this room and beyond. Datuk Seri Gopal Sriram's lecture is titled The Dynamics of Constitutional Interpretation, and we are honored to have him speak today.
There's something wrong with these steps. Every year they get higher and higher. To all the members of the Superior Judiciary of Malaysia, all the young Arifs, and I noticed that some of the old Arifs are also around. To all of you, ladies and gentlemen, very good afternoon. I want to thank Gayatri, whom I always regard as the daughter I never had. My original topic was going to be the mating habits and life forms of the Galapagos turtle. But I was told that that will be even more boring than the lecture I now propose to deliver. To avoid misunderstanding in the communication of the subject, I propose to actually read from the text. The first ever modern written constitution in the common law world is the Constitution of the United States. It was created on 17th of September 1787 and came into force on 4th March 1789. The amendments to the US Constitution, which are popularly known as the Bill of Rights, were the first code of fundamental rights, recognized as controlling the executive and the legislative branches of government. Coming as they did from a common law country, they had a positive impact on the draftsman of the Indian Constitution. India was the first predominantly non-white country to exit from the British Empire, thereby reducing the title of the British monarch from King Emperor to head of the Commonwealth. Although Canada and Australia had become self-governing nations before 1950, Canada introduced its Charter of Rights and Freedoms into their constitution only in April 1982, and Australia's constitution until today does not contain a chapter on fundamental rights. It has been largely left to judges of Australia to read into the constitution such rights as appear submerged in its express provisions and its structure. For example, in Lange, an Australian Broadcasting Corporation, the High Court implied the right to freedom of communication into the Constitution based on the provisions that deal with the holding of elections. In the other common law country with a written constitution is the Irish Free State. It came into existence in 1922. It had a chapter on fundamental rights, but it made little impression in the common law world at the time because the jurisprudence emanating from it was fairly recent. It was not until much later that Indian courts began looking at the courts of IRA for guidance on the interpretation of their fundamental rights and the approach to judicial review. When the fundamental rights provisions of the Indian Constitution came to be written, its framers went to the United States to consult Justice Felix Frankfurter, the recognized authority on US constitutional law. At the time, the US Supreme Court had about 200 years experience with interpreting the constitution of the republic, republic. Frankfurter advised the Indians against the use of the expression due process in the article protecting life and liberty. That phrase had caused the American judges a headache because of the opinion held by some American jurists that it included both substantive and procedural due process. Instead, he suggested that the Indians adopt Article 21 of the Japanese Constitution. That constitution had been written by the Americans for the Japanese after the end of the Second World War. Article 21 of the Japanese Constitution reads, "No person shall be deprived of his life or personal liberty save in accordance with procedure established by law." And that is how Article 21 of the Indian Constitution came to be. In the case of the Malaysian equivalent, Article 5.1, which reads, "No person shall be deprived of his life or personal liberty, save in accordance with law," is drawn partly from Article 21 of the Indian Constitution and partly from the Irish Constitution. The phrase "life or personal liberty" is taken from the Indian Article 21, whilst the phrase "in accordance with law" is taken from the Irish Constitution. Between 1950 and 1970, several former British colonies obtained their independence. Their constitutions, like the constitutions of India and Malaysia, are all modelled along Westminster lines. And they all have a chapter on fundamental rights. All of them had now to cope with the process of interpreting their respective constitutions. Early days. Because of the absence of a fundamental rights chapter in the Australian and Canadian constitutions, as well as the Dominion legislation in India, the cases decided by the Indian, Australian and Canadian courts, as well as the Privy Council on constitutional interpretation before 1950, must be read with great care. The expressions used in those cases were in the context of federalism. We have the following statements as pointers. First, in James against Commonwealth of Australia, Lord Wright said, "The question then is one of construction, and in the ultimate resort must be determined upon the actual words used, read not in vacuo, but as occurring in a single complex instrument in which one part may throw light on another. The Constitution has been described as the Federal Compact, and the construction must hold a balance between all its parts. Though the question here is not as to the division of powers between the Commonwealth and the states, but as to the existence in the Commonwealth of the power which is impugned, yet it is appropriate to apply the words of Lord Selborne in Queen and Bura. It is true that a constitution must not be construed in any narrow and pedantic sense. The words used are necessarily general, and their full import and true meaning can often only be appreciated when considered as the years go on in relation to the vicissitudes of fact which from time to time emerge. It is not that the meaning of the words changes, but the changing circumstances illustrate and illuminate the full import of that meaning. It has been said that in interpreting a constituent or organic statute, such as the British North America Act, the construction most beneficial to the widest possible amplitude of its powers must be adopted. But that principle may not be helpful where the section is, as Section 92 may seem to be, a constitutional guarantee of rights, analogous to the guarantee of religious freedom in Section 116, or of the equal right of all residents in all states in Section 117. The true test must, as always, be the actual language used, nor can any decisive help be derived from the evidence of extraneous facts existing at the date of the Act of 1900. Such evidence may in some cases help to throw light on the intention of the framers of the statute, though that intention can in truth be ascertained only from the language used. Thus, they presumably and did not anticipate those commercial and industrial difficulties which have in recent years led to marketing schemes and price control or traffic regulations, such as those for the coordination of rail and road services, to say nothing of new inventions such as aviation or wireless. The problems, however, of the Constitution can only be solved as they emerge by giving effect to the language used. The case of James had to do with Section 92 of the Australian Constitution. That section provides that trade, commerce, and intercourse among the states shall be absolutely free. The question was whether it bound the federal parliament as well as the states. James was a grower and processor of dried fruit. He sent his produce from Port Adelaide to Sydney. The federal government seized the goods pursuant to the Dried Fruits Act 1928, which was a federal statute. James brought suit against the federal government claiming that the act in question was ultra vires Section 92 of the Constitution. The High Court of Australia struck out the suit. On appeal, the Privy Council found for James and restored the writ to file. James was therefore a case of a contest between federal legislative power and the Constitution in the context of interstate trade and commerce. It was not a case of fundamental rights. The other authority is INREE, Central Provinces in Berar Sales of Motor Spirit and Lubricants Taxation Act, where Sir Maurice Guyer, then Chief Justice of the Indian Federal Court, said that the Judicial Committee have observed that a constitution is not to be construed in any narrow and pedantic sense. The rules which apply to the interpretation of other statutes apply, it is true, equally to the interpretation of the constitutional enactment. But their application is necessarily conditioned by the subject matter of the enactment itself. Especially is this true of a federal constitution with its nice balance of jurisdictions. I conceive that a broad and liberal spirit should inspire those whose duty it is to interpret it. But I do not imply by this that they are free to stretch or pervert the language of the enactment in the interests of any legal or constitutional theory. That case had to do with a contest between the central government of India and the government of the province of Berar. At issue was the question whether the right to impose a tax came within the federal list or the state list. In other words, it was in the context of federalism, not fundamental rights. It had nothing to do with the enforcement of fundamental rights. Literalism. The very first case in the Commonwealth on the interpretation of a fundamental right was A.K. Gopalan against the state of Madras. It reflects the lowest ebb in the field of interpretation of human rights guaranteed by written constitution. It was a case of first impression, as the fundamental rights provisions of the Indian constitution had never been tested before. The facts of the case are not difficult. Gopalan was convicted and sentenced under the ordinary criminal law, but his convictions were quashed on appeal. While under detention, he was served in an order made under Section 3(1) of the Preventive Detention Act 1950. He petitioned for habeas corpus, challenging the Act of 1950 as offending several articles of the Indian Constitution, including Article 21. Gopalan raised a number of arguments in support of his claim, anchored on Article 21. The Supreme Court rejected all of them. In the event, the following four, among other propositions, were laid down. 1. The expression law in Article 21 does not encompass the rules of natural justice. According to Chief Justice Kania, the argument that law meant law in the abstract sense and that it included the rules of natural justice was not proper and indeed misleading. Following from the first proposition, the expression law in Article 21 means enacted law. That was so held by Justice Patanjali Sastry, who concurred with Justice Kania. Justice Mukherjee was of the same view, and so was Justice Das. That brings us to the third proposition. To come within the article, that is Article 21, the supplicant must show a complete loss of personal liberty. A partial violation of the right was insufficient. And that is what Chief Justice Kania held, in which the other judges forming the majority concurred. This last proposition has been permanently laid to rest in Malaysia by the decision of our Supreme Court in Dewan Undangan Negeri Kelantan against Nordin bin Saleh, where it was held, quote, in testing the validity of the state action with regard to fundamental rights, what the court must consider is whether it directly affects the fundamental rights or its inevitable effect or consequence on the fundamental rights is such that it makes their exercise ineffective or illusory. The fourth proposition in Gopalan is that in interpreting the fundamental rights provisions of the Constitution, resort may be had to parliamentary debates. This last principle, though it offended the canons of statutory interpretation as they stood in 1950, was ahead of its time, as evidenced by the decision of the House of Lords in Pepper and Hart in 1993. Gopalan's case was decided by judges with a predilection to the so-called rule of literal interpretation. Hence, they adopted a restrictive approach when construing Article 21 of the Indian Constitution. But even at the time the judgments in Gopalan were delivered, there were judicial pronouncements already calling for a liberal interpretation. James and Commonwealth, in the Central Provinces cases, provide examples that were readily available to the judges of the Supreme Court who took the literal route. But it is possible that these cases were not referred to by the court because they had nothing to do with the enforcement of fundamental rights. Rather, they had to do with the allocation of legislative power between the federal and state legislatures. A reading of the judgments in Gopalan's case leaves no room for doubt that the petitioner there was seeking to move the Supreme Court to adjudicate on the reasonableness of the Preventive Detention Act. Hence, the submission that the rules of natural justice should be read into Article 21. Justice Fazl Ali, who delivered the sole dissent, was persuaded by this argument. That very learned judge was prepared to hold that the rules of natural justice should be read into the expression procedure established by law, as the Audi Altram Partem rule was part of the general law, but the majority was not. The result of the majority view is that all that Parliament has to do is to pass a law establishing a procedure, even a draconian procedure, and all that the executive had to do was to follow that procedure. Once it does so, its actions are beyond judicial review. In short, Parliament may by ordinary legislation deprive a person of his or her personal liberty by means of a harsh and oppressive procedure, and there is nothing the courts could do about it. It cannot be gainsaid that the decision in Gopalan rendered the fundamental right guaranteed by the Constitution illusory, providing as much protection to the individual as a well-knit cotton shirt against a machine gun. In the early history of the Constitution of the Irish Supreme Court, the Irish Supreme Court also adopted a literal approach to its constitutional interpretation. In the state, ex rel Ryan against Lennon, the court considered the power of the legislature to amend the Constitution. In that context, the court referred to Article 440, bracket 4.1 of the Constitution, which provides no citizen shall be deprived of his personal liberty save in accordance with law. It then went on to say, quote, when a written constitution declares that the liberty of the person is inviolable, but goes on to provide no person shall be deprived of his liberty save in accordance with law, then it is a law passed that a citizen may be imprisoned indefinitely upon a letter de cachet signed, letter de cachet signed by a minister, or as we have seen, even by a minister's clerk. The citizen may be deprived of his inviolable liberty, but the deprivation will have been in accordance with law. He will be devoid of redress, and he would have been as he would have been under the regime of a French or Neapolitan Bourbon. In Socky Docks against government of Mauritius, Lord Templeman, when delivering the advice of the Privy Council, appears to have treated the expression law in the constitutions of Malaysia and Mauritius as meaning enacted law. Like the Supreme Court in Gopalan's case, Malaysian courts in the early history of our constitutional development favored the literal approach to interpretation of fundamental rights provisions and took a narrow and pedantic view of the interpretation of fundamental rights provisions in the federal constitution. As observed by the Malaysian Court of Appeal in Deputy Chief Police Officer against Ramesh, now in the early days of the development of our jurisprudence, our courts adopted a narrow and literal approach to the interpretation of the federal constitution, in particular those provisions which confer fundamental liberties upon our citizens. The decision of the former federal court in the government of Malaysia against Loh Wai Kong is illustrative of this. It was the lowest ebb in the history of our constitutional life. The executive was virtually handed a carte blanche by the courts in the matter of citizens' fundamental rights. It was one of the darkest moments in our legal history. In Comptroller General of Inland Revenue against NP, the court, adopting the positivistic approach, held that the expression law in Article 13(1) of the Federal Constitution refers to enacted law. In that case, the taxpayer challenged the validity of provisions in the Income Tax Act that on the ground that they infringed Article 13(1) of the Constitution. It was held that the expression law in Article 13(1) meant enacted law. And Justice Chang Min Tat, in arriving at his decision on the point, was guided by the decision of the Supreme Court of Burma in the case of Tinsa Warnang against the Commissioner of Police Rangoon. In the Burmese constitution, Article 16 provided, no citizen shall be deprived of his personal liberty save in accordance with law. After holding that law in that article meant enacted law, the Supreme Court went on to say that it did not include the rules of natural justice, but merely enacted law. In Government of Malaysia against Arumugam Pillai, Justice Chang Min Tat once again reiterated the position he had taken in Controller General of Inland Revenue against NP. And he said that it can be no doubt that income tax is deprivation of property in accordance with law, or that the Income Tax Act was duly enacted. Taxing, therefore, cannot be said to be inconsistent with the Constitution. In Government of Malaysia against Loh Wai Kong, the Federal Court of Malaysia gave the expression personal liberty in Article 5.1 of the Constitution a narrow meaning by applying the judgment of Justice Mukherjee in Gopalan's case. The strict or literal constructionist approach to a fundamental right was also adopted by the Federal Court in Ketua Polis Negara against Abdul Ghani Harun in 2001. That is a case in which Justice Hishamuddin had held in the Shah Alam High Court, a judge of great distinction, Justice Hishamuddin, that a détenu who moved the court for habeas corpus was entitled to be present at the hearing of his petition. The Federal Court on Appeal reversed. Where complaint is made, and this is what the Federal Court said, this is what the Federal Court said. Now the wording in Article 5.2 of the Constitution, given their natural and ordinary meaning, seem to show clearly that the High Court or any judge that shall order the detainee to be produced in court and release him after being satisfied that the detention is unlawful. In other words, Article 5.2 of the Constitution does not envisage the production of a detainee at the hearing of his habeas corpus application. It may be seen from the foregoing discussion that the approach of the literal interpreter is to look at the text of a fundamental rights provision and no further. Two principles guide them. First, to go to no further than the natural and ordinary meaning of the words employed by the framers of the Constitution. Second, to apply to the human rights provisions in a Constitution the same canons of interpretation that are applied when interpreting ordinary legislation. A leading textbook of its times, Clement on the Canadian Constitution, said in a passage quoted with approval by Lord Sankey in Edwards against the Attorney General for Canada, the Privy Council indeed has laid down that courts of law must treat the provisions of the British North America Act by the same methods of construction and exposition which they apply to other statutes. The demise of Gopalan. The decision in A.K. Gopalan met its demise in stages, beginning with R.C. Cooper against Union of India, Sambhunath Sarkar against the state of West Bengal, and Bennett Coleman against Union of India. Bits of the reasoning in Gopalan were eroded. Then its final death blow was dealt in Maneka Gandhi against the Union of India. The following passage in the judgment of Justice Bhagwati puts the matter beyond doubt. Obviously, procedure cannot be arbitrary, unfair, or unreasonable. This indeed was conceded by the learned Attorney General, who with his usual candor frankly had stated that it was not possible for him to contend that any procedure, however arbitrary, oppressive, or unjust, may be prescribed by the law. There was some discussion in A.K. Gopalan's case in regard to the nature of the procedure required to be prescribed under Article 21, and at least 3 of the learned judges out of the 5 expressed themselves strongly in favor of the view that the procedure cannot be arbitrary or fantastic or oppressive procedure. Justice Fazil Ali, who was the minority, went the farthest limit in saying that the procedure must include the 4 essentials set out in Professor Will's book on constitutional law, namely notice, opportunity to be heard, impartial tribunal, and ordinary course of procedure. Even on principle, the concept of reasonableness must be projected in the procedure contemplated by Article 21, having regard to the impact of Article 14 on Article 21. Article 14 of the Indian Constitution is pari materia to Article 8.1 of the Malaysian Constitution. If the decision of the Indian Supreme Court in Maneka Gandhi were insufficient to provide a decent burial to A.K. Gopalan, the landmark decision in the Privy Council in Ong Ah Chuan did the job quite well. Though a decision from Singapore, the relevant articles of the Constitution of Singapore that came up for consideration were ipsissima verba, the federal constitution. The case therefore has an impact on the articles housed under Part 2 of our Constitution. To summarize Ong Ah Chuan, the authority To summarize, Ong Ah Chuan is authority for the following propositions. 1. A constitution modelled along Westminster lines. In a constitution modelled along Westminster lines, reference to law in a chapter on fundamental rights is to a system of law of which the rules of natural justice are an integral part. Second, although the definition of law includes written law, this only refers to a law that is valid and operative. It must be a written law that is not inconsistent with the Constitution. Accordingly, when a challenge is taken as to the constitutionality of written law, the court is not relieved from determining whether the law in question is inconsistent with the Constitution. The propositions that found favour with the majority opinion in Gopalan cannot stand side by side with the advice of the board in Ong Ah Chuan. Accordingly, at least so far as Malaysia is concerned, there is no life after death for Gopalan. It is well and truly consigned to the grave. As such, the decision of the federal court in Low Wai Kong, which relied so much on the judgment of Justice Mukherjee in Gopalan, must be treated as bad law and no longer binding on our courts. There are other reasons why Low Wai Kong should join Gopalan in the adjacent grave will be discussed in a moment. Our courts, from the literal to the prismatic. Our courts, like the courts of India, Burma and Ireland, adopted the literal approach to the provisions of our Constitution, particularly those housed in Part 2, and they applied to the provisions of our Constitution the same canons of construction as those used by courts for the interpretation of ordinary acts of Parliament. In Low Wai Kong, Lord President Safyan said that it is well settled the meaning of words used in any portion of a statute, and the same applies to a constitution, depends on the context in which they are placed, that words used in an act take their colour from the context in which they appear, and that they may be given a wider or more restricted meaning than they ordinarily bear if the context requires it. Close quote. The application of a canon of statutory construction to words appearing in a fundamental rights provision is clearly wrong, even given the jurisprudence then in existence. As Lord Diplock said in Hines in 1977, to seek to apply to constitutional instruments the canons of construction applicable to ordinary legislation in the fields of substantive criminal or civil law would, in their lordships' view, be misleading. Although Hines was decided 2 years before Low Wai Kong, it was not referred to by the federal court in its judgment. Perhaps if the court's attention had been drawn to Hines and the other contemporaneous decisions, the approach taken may well have been different. It is noteworthy that the view expressed in Hines has been reiterated fairly recently by the Indian Supreme Court in the case of Ashok Tanwar against the state of Himachal Pradesh. In Peha Birkwasa Negri Sabha against Sugumar Balakrishnan, the federal court rejected the broad and liberal approach by the Court of Appeal, of which I was a member, and delivered judgment, and instead affirmed the literal, narrow and pedantic approach in the following words. I won't read the whole of it, but all that is said is that the words personal liberty are not to be interpreted generously but narrowly. The stamp of distortion left upon Malaysian constitutional law by Sugumar Balakrishnan has since been erased forever by the federal court in Datuk Seri Haji Muhammad Nizar bin Jamaluddin against Datuk Seri Dr. Zamri bin Abdul Qadir. Canons of statutory constructions are not to be applied when interpreting our constitution. Although the actual ratio in that case is quite wrong, there are some invaluable gems in the judgment of Chief Justice Arifin Zakaria that point us in the right direction on the path to constitutional interpretation. If one were asked to identify the single most important case in the history of constitutional interpretation, it must be Minister for Home Affairs against Fisher. The advice of the committee delivered by Lord Wilberforce establishes the following propositions. 1. A written constitution is an instrument that is sui generis. Therefore, the canons of construction employed in the interpretation of ordinary statutes do not apply to constitutions. But this does not mean that there are no principles guiding a court when interpreting a constitution. Second, the provisions of a constitution, especially those that guarantee fundamental rights, must be interpreted with less rigidity and greater generosity Full recognition and effect must be given to the fundamental rights and freedoms that are guaranteed by the Constitution. Number 3, a court interpreting the fundamental rights provision in a constitution modelled along Westminster lines must avoid what Professor S.A.D. Smith referred to in his seminal work on judicial review as the austerity of tabulated legalism. In summary, there is no room for a literal interpretation of a written constitution modelled along Westminster lines. The principles set out by Lord Wilberforce in Fisher were adopted by our federal court in Dato Menteri Osman Baginda against Dato Ombi Said Ali. Our apex court has gone further to enunciate that several principles that guide the interpretation of fundamental rights. The first of these is that it is misleading to apply canons of statutory construction when interpreting the Constitution. This is because, among other things, it is the supreme law of our country. The second is that in interpreting fundamental rights entrenched in Part 2 of the Constitution is on no account should be a literal approach. On no account should a literal approach should be adopted. The result is that cases such as Ketua Police Negara against Abdul Ghani Harun and Loh Wai Kong must be treated as no longer good law. There is a further reason for rejecting Loh Wai Kong as precedent. In that case, Loh Wai Kong brought an action under Section 41 of the Specific Relief Act against the government, claiming relief for refusing him a passport. Justice Gan Chitwan, later Chief Justice of Malaya, a most careful judge, dismissed the claim. In other words, the government succeeded. Ladies and gentlemen, the government succeeded. They won the case. But in the course of his judgment, he made an observation. Justice Gunn made an observation. He said that the right to travel abroad is a fundamental right. The government was not happy with this comment. In accordance with the procedural law as it stood at the time, and even as it stands today, a successful litigant cannot appeal against a comment or observation in a judgment. The federal court had no jurisdiction to entertain the appeal, yet the government purported to appeal. Nobody objected, but that makes not a jot difference. No, because neither consent, estoppel or waiver may confer jurisdiction upon a court that lacked it ab initio. Besides, only a lunatic will appeal against a decision in his favor. Unfortunately, the federal court purported to hear and allow the appeal. How on earth this happened is a mystery, considering, as you must, the strength of the bench that sat. But the upshot is that the judgment is that of a court acting without jurisdiction. Loh Wai Kong was a case decided by a court acting without jurisdiction. Despite this proposition being as plain as a pikestaff, we have courts, even today, at the level of the Court of Appeal saying that they are bound by Loh Wai Kong. The third principle of constitutional interpretation is this: when interpreting the rights guaranteed by Part 2, the court should adopt a prismatic approach. This is because the concepts that are employed in several articles have submerged in them other specific rights. As Lord Hoffman said in Boyce and the Queen, quote, parts of the Constitution, and in particular the fundamental rights provisions of Chapter 3, are expressed in general and abstract terms, which invite the participation of the judiciary in giving them sufficient flesh to answer concrete questions. The framers of the Constitution would have been aware that they were invoking concepts of liberty such as free speech, fair trials, and freedom from cruel punishments, which went back to the Enlightenment and beyond. And they would have been aware that sometimes the practical expression of these concepts, with what limits on free speech are acceptable, what counts as fair trial, what is cruel punishment, had been different in the past and might again be different in the future. But whether they entertain these thoughts or not, the terms in which these provisions of the Constitution are expressed necessarily co-opts future generations of judges to the enterprise of giving life to the abstract statements of fundamental rights. The judges are the mediators between the high generalities of the constitutional text and the messy detail of their application to concrete problems. And the judges, in giving body and substance to fundamental rights, will naturally be guided by what are thought to be the requirements of a just society in their own time. In so doing, they are not performing a legislative function. They are not doing repair work by bringing an obsolete text up to date. On the contrary, they are applying the language of these provisions of the Constitution according to their true meaning. In the case of Malaysia, there is statutory backing for the suggested approach. The Federal Court in Public Prosecutor against Gan Boon An very recently accepted this. This is what the Apex Court said. Quote, consonant with the generous and liberal construction conferred the Constitution, it was held that the phrase in accordance with law in Article 5.1 is wide enough to cover procedure as well. See Re Tan Boon Liat. And which procedure must not be arbitrary or unfair. See Tan Teck Seng. Implies a fair trial in both procedure and substance, and within a reasonable time by an impartial court established by law, and accords a fundamental right of access to justice. It was also enunciated that Article 5.1 guarantees that neither life nor personal liberty may be deprived save in accordance with law. Article 5.1 stipulates that no person shall be deprived of his life or personal liberty save in accordance with law. This right to personal liberty is not absolute, is subject to qualifications. The key to the issue herein lies in the phrase save in accordance with law, since no person, including the respondent, can be arrested, detained or imprisoned unless authorized by law. See an introduction to Constitution of Malaysia by Tun Muhammad Sufyan bin Hashim, 2nd edition. It is important therefore to consider the phrase save in accordance with law. In Muhammad Azam, it was held that the phrase save in accordance with law in Article 5.1 requires that there must be a specific and explicit law that actually provides for it. The Federal Court, in the case of Che Aini, adopted the meaning of the word law in the phrase save in accordance with law given by the Privy Council in the Singapore case of Ong Ah Chuan, where it was held that the term law in the phrase refers to a system of law which incorporates those fundamental rules of natural justice that had formed part of the common law of England and was in operation in Singapore at the commencement of the Constitution. Pertinent to law is the phrase in accordance with law. Article 160(2) of the Constitution, Federal Constitution, stipulates that law includes written law, the common law insofar as it's in operation in the Federation, or any part thereof, and any custom or usage having the force of law in the Federation or any part thereof. With that common law being the common law of England, the Federal Constitution read with Section 66 of the Interpretation Act. Article 160(2) uses the word includes, hence Article 160(2) is a non-exhaustive definition. The phrase in accordance with law does not merely refer to domestic law, but also to the rule of law. It includes the doctrine of presumption of innocence and does not exclude case law, judge-made law, legal doctrines established by judicial precedents, or whatever that has force of law, close quote. The fourth principle is this: while the guaranteed rights are to be read generously, derogations upon a right are to be read down. That is to say, they should be read narrowly and restrictively. This is achieved by applying to such derogations the doctrine of proportionality that is housed in the second limb of Article 8.1 of the Federal Constitution, that is the Equal Protection Clause. This has been laid down by the Apex Court in Public Prosecutor against Azmi bin Sharon in a very learned judgment by Chief Justice Arifin Zakaria. The fifth principle is as follows. When interpreting a constitution that's modeled along Westminster lines, it is a cardinal principle of interpretation that there are embedded in the structure of the constitution the basic features that are common to all such constitutions. Neither executive nor legislative state action may violate the basic structure of the constitution. Westminster models are based on parliamentary democracy. To remind, Malaysia is one such model, and it is a parliamentary democracy. Lord Steyn, in the State of Mauritius against Abdul Rashid Koirati, explained the concept as follows, quote, the idea of democracy involves a number of different concepts. The first is that the people must decide who should govern them. Secondly, there is the principle that fundamental rights should be protected by an impartial and independent judiciary. Thirdly, in order to achieve a reconciliation between the inevitable tensions between these ideas, a separation of powers between the legislature, the executive, and the judiciary is necessary. Close quote. In Hines, Lord Diplock recognized that the doctrine of separation of powers will not find express mention in a constitution that is designed along Westminster lines. Because of this, it is necessary for courts to interpret the Constitution as a whole to discover whether there is any intention by the framers to vest the judicial power in either the legislature or the judiciary, or the executive. If that intention is excluded, then we can safely say that the Constitution incorporates the doctrine of separation of powers, and therefore a statute may be struck down for breach of that doctrine because of the basic structure of the Constitution. Because of the commonality of the basic structure of these negotiated constitutions, it comes as no surprise that countries within the Commonwealth may learn from each other through cases decided in each of the several jurisdictions in the matter of how a structured constitution should be interpreted. In Koirati, Lord Roger of Earlsbury made the point. The basic structure doctrine. That then brings us to the all-important question. Is an ordinary act as well as an act amending the Constitution liable to be struck down on the ground either one, that it violates the doctrine of separation of powers, or two, that it violates the basic structure of the Constitution? Let me take each instance separately. In the case of an ordinary act of Parliament, it is settled law that a statute may be struck down as violating the doctrine of separation of powers. There is no dearth of authorities that support the proposition. Commencing from Leonardo and the Queen in 1967, Hines, which was quoted by Lord Diplock in Hines, Director of Public Prosecutions of Jamaica against Morrison, decided in 2003, and Koirati, decided in 2006, the Privy Council has consistently upheld the striking down of statutes that infringe upon the judicial power of the state and hence violate the doctrine of separation of powers. Let it therefore be said, without the slightest of doubt, that the decision of the majority of the Federal Court in Public Prosecutor against Kokwa Kwan, which held that there is no such thing as a right in a court to strike down a statute for breach, for violation of the doctrine of separation of powers, is wrong, and that the unanimous judgment of the Federal Court in Simini Jaya, Sindrian Berhad, is correct. And there should be no hesitation on the part of any jurist or lawyer to recognize that the utmost congratulations must be conveyed to Her Ladyship Justice Zainun Ali for a well thought of and carefully written judgment. It may be safely said that Simini Jaya has now correctly consigned the majority decision in Kokwa Kwan to the judicial waste bin where it rightfully belongs. Simini Jaya is now authority for the following propositions. 1. An ordinary act of Parliament that violates the doctrine of separation of powers by striking at the judicial power of the Federation may be struck down on that ground alone. Second, an ordinary act of Parliament that infringes the doctrine of judicial independence may be struck down on that ground alone. But it is not only these reasons that make Simini Jaya a case of first importance. And that brings me to the second instance I mentioned a moment ago. The doctrine of separation of powers and that of judicial independence form part of the basic structure of the Constitution. This proposition was recognized by Hines and its progeny. Therefore, any act, including an act amending the Constitution in accordance with the provisions of Article 159(1), may be struck down as violating the basic structure of the Constitution. Because the judgment in Simini Jaya has come up for criticism, it becomes necessary to show that the case is good law and that the decision of the former Federal Court in Lo Kui Chun and the cases that followed it were, with respect to the strength of the bench, in all those cases, wrongly decided. And may I add this, it is not my fault or the fault of anyone here that those who decided Kokwa Kwan to hold that this doctrine of separation of powers is not a ground for nullifying a statute. It's not any of our fault that those who wrote the judgment were sick on the day they were teaching constitutional law in class. First, the federal court in Lo Kui Chun and the cases that followed it failed to have regard to the vital difference that between the Vairis provision, the vital difference between the Vairis provision in our constitution and that housed in the Indian constitution as it stood before 1971. Second, its harmonization of Article 4.1 and the amending power of Article 159 is not in accordance with settled principles of constitutional interpretation and has therefore produced an incongruent result. This resulted in creating a difference between the word law referred to in Article 4.1 from the words federal law referred to in Article 159. Third, the starting point of the court in Lo Kui Chun appears to have been based on principles governing the British Constitution without having regard to fundamental differences between it and our written Constitution. Fourth, it failed in conferring Parliament unfettered power to amend our Constitution to distinguish between procedure and substance. But last but not least, the two important cases that followed Lo Kui Chun left the door open on the issue whether the basic structure doctrine applies to our Constitution. In the rest of the paper, I deal with the grounds in detail, which I don't think are really, will not produce any further knowledge than is already contained in the existing text, except to induce sleep among the audience. So I now turn to the concluding remarks I make. Very quickly. The dynamics of constitutional interpretation changes as we acquire more knowledge about how we must approach our Constitution. We've moved away from looking at the supreme law as a last will and testament to an organic instrument that is constantly developing to meet new challenges to the rule of law and constitutional disobedience. In relation to Part 2, courts have moved away from the literal approach to the generous and prismatic. And in defense of those who decided cases such as Lo Kui Chun and Pang Ching Hock, it must be said that our country from Merdeka had been ruled by politicians, most of whom were lawyers. Tunku Abdul Rahman was a lawyer. Tun Razak was a lawyer. In fact, he came from my inn. Certainly, our first three prime ministers were barristers trained in the common law system of the rule of law. They were men of unimpeachable honesty and who had no cronies and whose only aim was to bring us prosperity as a nation without sacrificing the rule of law. So the judges of the time were confident that they should be allowed to rule within the broad framework of the Constitution, which all thought should be read literally and which conferred wide powers of legislative intervention in the interests of good governance. They had no crystal ball to know that a non-lawyer would come to rule, who had as much respect for our Constitution or the rule of law as a discarded prescription given by a doctor. And so came the destruction of our institutions one after another in the name of economic progress. And by the time the poison had set in, it was too late. For we had inherited judges who had held on to the outdated modes of constitutional interpretation and who were largely guided by the mutatis mutandis application of the medieval doctrine that the government can do no wrong. It was not until the late 1980s that the judiciary woke up to the fact that the Constitution required defending from the very persons who had sworn before Parliament that they would uphold it and defend it. It is against that background that we should view the early dynamics of constitutional interpretation. Our courts began with a strict interpretation of the phrase the law in the several articles of Part 2 to mean positive law or enacted law. We have now arrived at the point where we should have begun, by recognizing that law means use and not lex. We have now arrived at the point where our courts stand poised to perform their true role as protectors and defenders of the Constitution and the rule of law by checking legislation that strikes at the very heart of our Constitution and at its basic structure. But there are among us those unfamiliar with the developments of our apex court that our apex court has made and who live like the proverbial frog in the well, unwilling or unable to think out of the box. They act upon precedent which has either been overtaken or contradicted by later cases. To these, one can only say, take an interest in the subject and read the latest decisions of the Federal Court and of the apex courts of other common law jurisdictions to widen your horizon. Otherwise, become members of the constitutional wrecking crew who destroy the rights of our fellow citizens by giving a free hand to voracious power seekers. Thank you.